Thank you very much, Les, for your presentation, also for being perfectly in time, exactly 20 minutes. Thank you very much for this. I think that you raised many interesting points. Maybe we have the opportunity to discuss some of them during the Q&A at the end of the session. Now we move to France and Luxembourg with Pierre-Henri Conac. Pierre-Henri Conac is professor of financial market law at Luxembourg University. He's a very well-known capital markets law and corporate law scholars at the EU level. He's not only a professor, but he's also very much involved in policy making. He is advising not only the French government and Luxembourg, but also at the EU level. So I think that is a great pleasure, great opportunity to listen what you think about France and Luxembourg on legal person as directors.
Okay, thank you very much. Thank you, Chris Tomale. Where is he? For inviting me.
There is a legal person now.
Bad luck. So I'm very pleased to be in Vienna. Hello, Matthias, also. I see so many friends and also exciting ideas, which were also put this morning. I mean, this is very good to have this kind of brainstorming. Because at first I thought, oh, they gave me a very boring topic because in France, nobody talks about this. But then we'll see. Oh, sorry. Okay, so I will do a very classic French approach. We'll speak about the regime of directors in France and Luxembourg. There are a lot of similarities. And also then how to protect against abuses. And also the other way around, which is what to do, because some people might not want to have legal directors because they fear liability. So in group situations, and so how do you deal with this? Oh, sorry. Okay, so for France, you have to start with the Companies Act of 1867, which I went through a bit again, and they don't speak about legal persons as directors. It's absolutely obvious, like in Austria or Germany, that they can only be natural persons. The idea doesn't even pop up, you know. So it's all about the guy. They insist a lot about the expertise of the director, you know, that he will bring to the board. The board is basically a representation of the shareholders. At this time also, you had these large companies, this AG, Société Anonyme, they were basically designed to be listed and to have connections. So you will appoint people who have the biggest shareholders. So they were control companies in a sense, you know, at least for many of them at the start. So of course, these guys will be the directors. Nobody speaks about non-natural person. In addition, you had this idea that since limited liability was at this time without authorization, this was mentioned this morning, there was no need for state approval for, you know, creating a public limited liability. There should be some guarantees for third parties. One of them was called the action guarantee. So you had to put some shares that you will lose if you mismanage. I mean, I guess it's classical. I think it was just a trade-off with the fact that now you could create limited liability companies without any state approval, and therefore there should be some protection. Instead of having ex-ante protection, authorization, you end up with ex-post protection. You lose part of your money at least. So this was the system. Then things change, and I think this is probably the key if we make an investigation into what happened. In 1940, it was decided in France that the chairman of the board and the CEO should be just one and same person. And at the same time, the civil liability and the criminal liability were dramatically increased. And this is a result of a crisis, the post-1929 crisis. So the 30s were a time of crisis, and there was a time where the board will be, in a sense, a bit unaccountable. There were scandals, and you had separation. So the chairman will say, oh, the CEO is responsible. CEO will say, hey, but no, I'm run by officially the board of directors run the show here. So nobody was really responsible at the end. And this, I think, you know, upset people. And when there was a change of regime at the time, it was then they say, well, it's just one guy there. And we apply him, you know, the fulcrum, the big sanctions will apply to him. And I think this is, and then in 1943, they say, well, this guy, he cannot be a legal person. It's the first time this appears. I think it gives a clue about what happened. Because now the risk of civil or criminal liability was higher. people got scared. And probably the practice started to appoint legal persons as CEO because the law said nothing because they never envisaged this. So in 1943, they had to fix this loophole. But in a sense, and because it was a dictatorship at the time, we have no preparatory works, but you can make the reasoning what happened. So they say we have to close this loophole because they are trying to escape liability, because at the time also you have no liability for legal persons. But also it means, in a sense, since you say he has to be a legal person, then what about the directors? Implicitly, it opens the door, but maybe it's not prohibited. So in France, it were a bit like in Switzerland, officially, actually, because in the mind it's different. Officially, if it's not prohibited, it's allowed. And the mind of people have seen this again and again and again. If it's not, authorized by the legislator, people get cold feet, and they don't like to do it. So they just call ministry, please change the law, change blah, blah, blah. So psychologically it's different, but legally it's freedom. So probably people thought, oh, okay, they say he has to be a natural person as a CEO, meaning it might be possible maybe for directors. And we see what happens afterwards. So in 1966, the new act is being introduced, like in Germany in 1965. All these reforms come, and they look at everything. They make a big act, and they say legal persons can be directors. And probably because after 1943, people start to say, well, why not do this, And but I didn't find one single article about the topic. This is very strange. Not one single article talks about this. Books from the 1930s don't even talk about this also. So I think this developed under the radar, basically, in the practice, and nobody looked at it until in 1966, when people said, well, let's make a new act. Some guy must have said, well, what do we do with a legal person? Because we have some. And then they say, okay, we do it. But then we appoint a permanent representative. That's what was the deal. So I think they decide to accept this practice, not create it, and just make it safe for those who are using it. Luxembourg. Just a few elements about Luxembourg, because you might not be familiar. So the Companies Act dates back to 1915, and it's basically at the time a kind of copy of the Belgium Act, which itself was inspired by the French Act of 1867, except that they tried to be more liberal. Why? Because Luxembourg, you might not believe me, but trust me, was very poor. It was a poor country. Yeah, it's true. They were immigrating in droves until they found some coal in the south of the country. Think about Liechtenstein. It was very poor until they dug the ground and they found a Finanzmarktplatz. But before it was very poor. So same thing for Luxembourg, not very rich. So they wanted to attract money. So they will be inspired by others. So many developments, including legal directors, they come from other countries. So they import SARL, the gamepad type, not from Germany, but from France, because Belgium had not adopted it. So we look at Belgium first, and if you don't find this in Belgium, we look at France. And if you don't really find it in France, then we look to Germany. That's how it works. And there's no influence really of EU law, except what is really necessary. Their motto is just the directive, nothing more than the directive, so no gold plating, because they want to be liberal. They are a bit directive averse in a sense, except if this is cross-border, because everything which is cross-border helps business, and Luxembourg lives from cross-border business. And one thing which has to be kept in mind is that, contrary to France, Germany, or Austria, most companies are basically a subsidiary of groups established for tax reasons. They are private equity investment funds. So it's not like, of course you have GmbH for, the Metzler or whatever, but you have 80% is, used as part of some intermediary schemes. So the company law is basically designed to serve the needs of a financial center, which will not, I guess, if you come from Germany, we say with Germany, well, this is not financial, it's not depends on the financial center. But here it's completely driven by this. So nothing can take place if it goes against the financial center, because this is what has to be supported. And company law is basically a tool, technical tool to help. Okay, so what did they do? They allow natural persons at the start in 1915, like in France. You have no inference that it could be legal persons. But then in 1962, it was decided in Belgium by Cour de Cassation in Belgium that they could be legal persons as directors. And since Luxembourg follows Belgium, it was also there. I found the first remark in the book of 1969 where someone writes, just in passing, well, it can be legal person, like, you know, it's not a question. So it's clear that it was a practice, but as in Luxembourg, they don't legislate unless there's a big reason to do it, because of a problem, a scandal, or EU directive, otherwise they do nothing. They just practice. So this was there at least in the 60s, probably like in France in the 40s and 50s before. It was only recognized in 2006 officially, though it was put in the law, just because the Società Europea had to be introduced. So they say, okay, let's make it clear, but it was there since ages. Okay, now let's look at what were the influence, in my view here. What drove this developments about legal directors, because Germany and Austria don't have it. It's not EU law, as Chris mentioned. EU is neutral on this, of course, because people are divided. I think it has first to do with group of companies. If you have a group of company, and in France, for Société Anonyme, you need at the time 7 shareholders, but you have, you know, 2 big shareholders, companies, and that's all, or 7 big shareholder companies. You want to have someone on the board. The board has to be made of natural person who need to own shares. So if you want to appoint someone, it means you need to sell a share or lend a share to one of your members. So it's a complicated system. So to have someone representing you, you have to get away with a share. So this is what it was done. You know, you have make a land of shares, but it's idiotic. You know, so it's much easier to say you can be representative of the parent company without having a share. You act as a legal person. So I think this is one of the reasons why this was recognized also, groups. But also I think there's another reason. Criminal liability, which I think is a big reason why people will not think that legal directors can exist, because we had no criminal liability possible for a very long time. In France, also in Luxembourg, it took a lot of time. In the 90s only it was accepted. And therefore you wanted someone with criminal liability to face. So this came very late. I think the reason why this was accepted or this developed in practice has to do with the opposite way. It's not to get, it's because 1940, 1943, you have an increase of a liability of directors and people get scared. And I think this is one of the triggers. So you have, I think, 2 triggers. One is the group, it makes management easier, but at the same time, you have the fact that you risk severe liability, especially it was untested in 1940, so don't know what will happen. And you feel code fit, let's have, you know, a legal person being there. And I think this is a reason why it developed. You know. Okay, so I will go a bit faster now for the, no, I forgot to start the count, okay. Well, you will tell me, Giovanni.
10 minutes.
Sorry?
10.
Well, that was my guess, good. So in France, system is directors can be legal persons, not senior officers, and not the chairman of the board. This is the old 1943 idea. The boss has to be the boss, huh? And he has to support. Yeah, I wouldn't say what you spoke about this morning. There were in France. There were always rumors that this was imported from Germany, by the way. So people, this is German, and not the best one. So we should not get rid of this. I think it's very French actually, because France, as you know, it's psychologically a monarchy. So people enjoy that. So they don't like separation of power. Okay, so we didn't need the Germans to come with this. So a supervisory board, 2-tier system, directoire, Vorstand, no legal persons, because they have the managers. Which brings back to my point. Probably it was because parent company wanted to appoint directors. They needed to have shares. If you're a senior officer, you don't need to have shares. So this might be one of the reasons also why the exception was framed only for directors. Okay, Luxembourg. So Luxembourg, very liberal, you know, needs to attract money. So Luxembourg takes what is around and removes, you know, everything which looks like others don't like, and see if it works. So Luxembourg, anybody can be a legal person. So the one-tier board, director, chairman of the board, CEO, yeah, legal person. Also think it's a country with a lot of group structures. So this makes a lot of sense for them. So these are for the Société Anonyme, the Aktiengesellschaft. Now let's look at other limited liability companies. The French SARL, only natural person. Easy to understand. This is Unternehmen, Familienunternehmen. So what is a legal person? It's a family business. So this stayed like this, imported from Germany, and it has not changed. But the SAS is different. Because in the case of a Société par Action Simplifiée, the simplified public limited liability company, which is a huge success, it's a very contractual stuff. And here, senior officers can be legal persons. And same as president. There's a catch here, I will explain. But why is it like this? When it was established in 1994, it was designed to be a joint venture structure because groups will create joint venture structures in the Netherlands. And this was humiliating for France. So it was decided to avoid that people go to Amsterdam to create their joint ventures through BV. So this system was developed, and because at the time, for SAS, you had to have two parent companies who were themselves legal persons, creating again the issue, but where is the share? Where is the missing share to be director? So this was removed completely, and they said, well, now anybody, legal person, can run the show. Why? Because it was designed to be for a group, as a group structure. Luxembourg, SRL, they can be legal persons. So, but it's not written in the law because the law has not so much changed since it was introduced in 1933. But practice again. So, and once it was decided, do we make this official? Say no, it's not necessary. Just a practice. But there's a big catch here, because a lot of activities in Luxembourg are designed for a financial center. You remember what I mentioned at the start. And as soon as you are, financial, you get into regulation, prudential issues. Running a bank, running investment firm, running investment fund. What does it mean? You need fit and proper test. Like in Switzerland, you need to have good repute. You cannot have this on a legal person. So it means that a huge part of a business will still have to be run by natural persons because they need to be approved by the supervisor. So you cannot show up a CV of a legal person, it will not work. What's your experience and so on. So it's very liberal, but large swaths there in Luxembourg will be subject to not being natural person because of the nature of the business being run there. Okay, protections against abuses. So the French solution, which comes from, I don't know exactly where, but I think a good one actually, is the legal person must appoint a permanent representative. So which person will face the same civil and criminal liability as if he was or she were a director in his or her own name. So it means you have two people who are liable now, the legal person and the natural representative, which means it's heavy, So people have to think twice about this. So the idea was, in any case, we find someone. We don't care about the upper structure. There must be some guy who is physically liable, civilly and criminally, and joint and several liability with the parent company. So if something goes wrong, they manage to stop themselves. Removal can be only done if there's a replacement done at the simultaneously. So you cannot say, I remove my permanent representative and I wait 6 months to appoint another one. In any case, I think it's a good corporate governance measure because you want someone to know the company, not someone who turns every 2 months, and then needs to learn, understand the system. Otherwise, this person will be, manipulated by the CEO and so on. So I think it's a good measure in any case, without the idea of liability. It's good to have something like this. Okay, SAS, sorry, I don't know why it's there, but there's no need to have a permanent representative, but in practice, there will be one. So they say it's liberal, it's for groups, no need, let's be flexible. But problem, the law, and the case law says Well, if you don't have a parent representative, then the CEO of the parent is liable. So thank you very much. So here we get a lot of parent representative because the CEO of the parent doesn't want to fall under this. Luxembourg, so to the system, Belgium also has the same system. I don't know if he came from France or whatever, but they have the same system. Parent representative, they even put it in the SS because they copy the French on the SS. Belgium has no SS, and they, which is strange because they went beyond the French here. But okay, in practice, France must have a parent representative for SS. And here it's interesting. This is very typically Luxembourgish. So same civil liability. What about the criminal one, which is applicable in France? Forgotten, verschwunden. Criminal liability. So in Luxembourg, you have the natural person, which represents the legal person, has the same civil liability as the parent. But nothing is being said about the criminal one. Surprise. So it's more attractive than France. Please set up your SAS in Luxembourg, not in France. So it means it's clearly the case that, it's a beneficial. It's a bit like Switzerland with already liberal and Liechtenstein, I guess. So Luxembourg always thinks, what can I do which attracts business, which makes the stuff more attractive than my neighbor? It's business. Okay. But now the real problem is, if it's a legal person who runs the company, in case of insolvency, liability will pop up, marked risk to pop up easily upstairs. So now groups might think this is dangerous. Because in a sense, yes, it's dangerous to have someone as a legal director just because the issue of shares, which is not solved by the way in France now, because you don't need to be a shareholder anymore to be director. So groups, what they do, at least in France, they don't appoint themselves as legal representative because this is problematic. So what they do, they appoint a natural person who is an employee of a parent, but who is technically independent. I mean, of course, independent. And sometimes as an employee, which means where's the independence? Because you have this subordination link. So then you have to deal with the issue of someone running the show from behind, but escaping liability because it's just, straw man, basically. So you have to come with a de facto director concept, which we all know. And what is interesting is that the French, so it's developed by case law, recognized in 1966. So they say de facto directors can be liable, okay? And case law has developed to say this is what it is. But what is interesting is that in France, even with people who are employees of a parent, to say that the parent is a de facto director is very rare. Which means to me that the courts realize that although the director from the sub is taking orders, this is clear, they still refuse to extend the liability upstairs because otherwise, if you do this, then you have no, you have no consent ratio, you have no group law, you have basically one big entity. So you destroy company law. If you say anybody who is appointed, then is just a tool, even if he's an employee or she's an employee. So this is a study in realism, judicial realism, that only if you can show that they had no way of saying anything else, that what they were ordered, they might be liable. But it's quite difficult. But in practice, we all know directors appointed who are employees of the parent. Of course, they are just tools. So here we have a kind of fiction, I think, interesting for lawyers, that the court say, okay, because if we say that as soon as you appoint someone who is an employee, which is done a lot, you are liable, then you destroy the concept of limited liability within a group. And therefore, you destroy the Companies Act. Okay, Luxembourg does the same, and except it's even more difficult in Luxembourg, surprisingly, to go after the parent company, which often will be foreign. So to conclude, I would say 1, 2, 3, 4 points. France is less liberal than Luxembourg. Okay, surprise. Like Austria is a bit more liberal than Germany. So, yeah. I was thinking about this morning, and I thought, I think the problem with Luxembourg, problem is so small, needs extra money from outside, but he has no choice. He has to be very liberal, a bit like Liechtenstein, but no, Liechtenstein is worse in a sense. Whereas Austria, problem is Austria, if I may, you're too big, guys. You're too big. So you're not under the same pressure. You can't afford to have loosey rules that you keep, or being too rigid. But Luxembourg cannot afford this luxury. So they have to go really the extra step. Okay, so I think this is really linked to the development of groups and also to the issue of liability. If you have risk of liability, then you might want to have legal persons, but then it goes upstairs. So I think it has to be a case-by-case analysis about which structure do you find yourself in, to whether to appoint or not legal persons. One question which is not answered, I find this very strange, is not even also in case law. Or permanent has to be the permanent representative, because permanent it's not explained by law. It does not say that you have to appoint for 3 years. It can be changed in between. So this is left for case law, but I've never seen a decision in France about how permanent is the permanent guy. So I think if you say 6 months, it could be okay. There's no rule here. And no case law, I didn't find any case law on this. Maybe I didn't look enough, but this is interesting. The law does not say how permanent. It should not be every 1 month you change, but maybe every 6 months could be acceptable. This would be left to court. And there are no special problems. This is what I've seen. No big problem with this. In conclusion, you don't see it, but it's about the 28 company law regime. You know that the Commission wants to create something integrated. First, they think about, regulation, Verordnung. I mean, forget about this because, it's a unanimity. So, I mean, it's just out of the picture immediately. Can be a directive, Richtlinie. But in this case, should the 28 communal regime solve the issue of legal directors? Because they want something integrated. So you have to take a decision in a sense. I think he will not fly in the council because you have German and Austrian opposing to this. So I don't know what the Commission will do with this. Will they come with a rule? Because here they're being asked, Commission is being asked to come with something as integrated as possible. So it's a good question to see whether having legal directors in the 28 communal regime will be accepted by the member states. I have some advice, some idea what could be done, but I would say caution. Okay, thank you very much.